There are two kinds of forfeiture in American law, and confusing them is the single most common mistake people make about this subject. So let us draw the line clearly. Start with criminal forfeiture, because it matches your intuition. It is the version you have seen dramatized on television. A defendant is convicted of running a drug trafficking operation. After the conviction, the government moves to take the proceeds and the instruments of that crime: the cash, the cars, the boat, the house. Notice the order of events. The conviction comes first. The forfeiture is a consequence of established guilt. The action runs against the person, and that person carries every protection you associate with criminal procedure: the right to a lawyer, the presumption of innocence, and proof beyond a reasonable doubt. Civil forfeiture inverts almost all of that. The action runs against the property itself. The property is the defendant. The owner is recast as a third-party claimant, someone who must intervene to assert an interest in an object that for obvious reasons cannot defend itself. And because the proceeding is labeled civil rather than criminal, the protections of the criminal law do not attach in the same way. There is no automatic right to an appointed attorney. The burden of proof is lower. The property enjoys no presumption of innocence the way a person would. Sit with how much rides on that single classification. Whether a forfeiture is civil or criminal determines what the state must prove, when it must prove it, and what defenses you can raise. Two proceedings can look almost identical from the outside. In both, the government is taking your property, and yet sit on completely opposite sides of the constitutional ledger. There is a strange consequence worth naming. Because the property is the defendant, the cases get named after the property: United States versus $250,000. California versus one Honda Accord. These are not jokes. They are real captions you can find in the law reports in Cite and Brief. The system is entirely serious about it, and once you stop smiling at the absurdity, the deeper point lands. We normally imagine the state as the plaintiff and the citizen as the defendant. Civil forfeiture flips that picture. The state is the plaintiff, the property is the defendant, and the citizen has to fight his way in just to defend something he already owns. That inversion is the engine of everything that troubles critics about this power.